Hi, students. So today the thing is, I noticed that I have two classes at the same time at 12 o'clock. I have jurisprudence with second year, and I have equity classes with you guys. So I have to get that fixed, but today I cannot. So what I thought is that today I will record the lecture and send it to you guys. So just go through it during your, watch it during your class hours, and I'll also be sending you the materials, relevant materials, and we go through that as well. And if you have any confusions, clarifications, ask them, seek clarification in the next class. But for today, I'll be sending this recorded lecture because at 12 I also have jurisprudence class. And I missed one class for them because I had a meeting the other day with the Vice Chancellor, not with the Vice Chancellor, with the exam department. So I'll have to take that class. So anyway, if there is any confusion, if any clarifications needed, you feel free to message me or ask me in the next class. So yes, today we will be looking at, I remember asking you guys to look at the definition of this thing, what do you call? Just a second. Yeah, I remember asking you guys to go through this two definitions that I suggested. Not definitions, two small readings, internet links, okay, in which you basically, you were supposed to read Aristotelian approach to equity, how equity is defined by Aristotle. So anyway, so if you go through this, if you just the other link that I had sent on equity, Aristotle on equity. So you find here him saying that justice, Aristotle said, has said, concerns following the accepted legal principles of the community on the one hand, and being fair in interpersonal transactions, that is not seeking to come out ahead at the expense of person you are transacting with on the other. But what about those cases in which strict adherence to law or to transactional proportionality seems wrong? I mean, the cases where if you adhere to the law, the outcome seems to be unacceptable, if not legally, then morally. Okay. So what about those cases? Okay. When mercy or charity or just the peculiar circumstances of some particular, I think someone's there.
I've joined. Do you have class right now?
Oh, Gargi, I'm sorry. What I'm doing is that I was recording this class because today I have two classes at the same time. Okay.
Oh, okay.
So I have juries as well as your class. So I didn't know what to do. So I was recording your class and I was going to share the recorded lecture with you guys. But you are welcome to be here.
Can I join?
Yeah, yeah, no issues, no issues. If
Okay,
there's anyone else, you can also join. I was just recording because I was going to share this with you.
okay, okay.
So kindly inform others as well. I'll be sharing this like recorded lecture as well as the PPT that I'm going to be making, by scanning the book. So I was discussing this thing. Okay, I had shared one link with you guys. I think one of them was not working. The other one was definitely working. Okay, where it discusses Aristotle's take on equity. So he basically says that there might be situation where strict adherence to general law or transactional proportionality might lead to might make you seem as if might give you the impression that something's wrong. Okay, so in such case what do you do? So he says, when mercy and charity or just the peculiar circumstances of particular case would seem to require us to make an exception to the law or to authorize an unproportional transaction. In fact, this is what I was trying to explain when I gave the example of you guys hurrying to the class. uh, uh, are there more students? Okay, so Gargi, kindly chat and tell them what I'm doing. Okay, and keep it. Okay, chat and tell others like what I'm doing. I was Paritosh, for your sake, like I was recording this lecture because I have two classes at the same time. So that's what I was up to.
So you won't be taking class at 12 today.
I won't be, because I have two classes. So there's some, mistake in the, there's something, wrong with the, what do you
A
call it?
timetable.
At a timetable. So I was recording this lecture, so I was going to share this with you guys. Okay. Because I also have a class at 12 o'clock with the jurisprudence batch. So don't
Okay,
worry.
okay, sir.
Tell me.
Okay, sir. So you will record this class and post it for all
Yeah,
the
yeah,
students
yeah.
for 12
Yes,
o'clock.
I was
Okay,
recording.
sir.
Yes, I was recording this. Yes.
Paritosh, please
Okay.
like text to the class group because everybody will be asking the same question again and
Ha,
again.
ha,
So
ha. Kindly inform
Yeah,
them
yeah,
about that.
yeah,
Okay.
yeah. I'll post it just right now. Okay.
Do that. Do that.
Okay.
So
Okay,
yeah.
sir. Then I'll post it in the class group and I'll meet you tomorrow because I'm just going to take bath.
Yeah, fine. No issues. I was going to record this anyway. No issues.
Okay, okay, sir. Thank you,
Yeah.
sir. Take care, sir.
No problem. Okay, so that's essentially what Aristotle says, that when strict adherence to the law leads to some kind of unacceptable outcome, then you do not strictly adhere to it. But you should have a justifiable cause of reason for deviation from the law. Okay, and those justifiable reasons are basically what equity is all about. So Aristotle says that equity isn't a virtue all its own, but that people with the virtue of justice ought also to have virtue of equity. There really is no thing as equity without justice, but equity with justice is better than justice without equity. So basically, application of equity leads to doing complete justice, as we discussed in the other class, if you guys remember. So equity provides you better standards of justice. Okay, so we do not assume that the positive law is unjust, merely that application of positive law, which is quite often very general in its nature, might lead to certain outcomes which might appear to be unjust. So to lessen the rigor of strict adherence to common law or other law, you need the softening touch of the law of equity. So they are not supposed to be taken as opposing each other, but as complementary or supplementary to each other. So they do complete justice by using different kinds of means. Okay, so that's why I had asked you guys to look at the definition of equity as has been given by Aristotle. So Aristotle says it is equity to pardon human failings and to look to the lawgiver and not the law. So what does he mean when he says that to look to the lawgiver and not the law? He merely says that the lawgiver would not intend to do injustice. Okay, so when you look at the law, if plain text application of the law leads to some kind of injustice, so you think of it as if as to whether the lawgiver would come to such conclusion. Okay, if you cannot, then you are to do equity. That's what he is essentially saying. So it is equity to pardon human failings and to look to the lawgiver and not the law, to the spirit and not to the letter, okay, to the intention, not to the action, to the whole, not to the part, to the character of the actor in the long run and not to the present moment, to remember good rather than evil, and the good that one has received rather than good one has done, to bear being injured to settle a matter by words rather than by deeds. Lastly, to prefer arbitration of judgments, for the arbitrator sees what is equitable but judges only the law, for this arbitrator was first appointed in order that equity might flourish. Okay, so I read an entire entire definition of equity as has been given by Aristotle. I'll also be sharing this with you guys. Do not worry. So what Aristotle essentially is saying here, that uh, equity means, as I have been repeating again and again, it means doing complete justice. So quite often, and also historically, it has been the case that there are certain facts, okay, the totality of the facts, which were not within the knowledge of the common law judge, okay, but which the chancellor, Lord Chancellor, essentially, initially could have recourse to, because he had this very peculiar jurisdiction and also peculiar powers. So he would have resort to complete facts, the entire facts. So in the light of that entire fact, he will be able to do better justice. Okay, so even, I'm referring to the English situation. So much before this, Aristotle had said something like that already, that you as a judge, when you are deciding the matter, you are to look at the entirety of the facts, okay, not just part of it. Okay, and when you look at the entirety of the facts, okay, you are able to do justice. Okay, and that justice is basically what equity is all about. It's not merely the common law justice, but also equitable justice. So that's the definition I had asked you guys to go back and read, and I'll be sharing this entire definition with you guys as well, so do not worry. So Aristotelian equity, that's essentially what it basically is all about. Okay, so he says that a just law formulates sound statements of general principle that are applied to all cases. Okay, so essentially common law, what it does is that it has certain general principles. If you remember Austin's definition, just a second, I'm getting a call. Hello, I'm class nichi por phone kori. So yes, so quite often what happens is that the laws which are made by the sovereign, okay, are general in their nature. They do not target individuals. Okay, quite it does many times, but usually that's not the case. Okay, you as a lawmaker will only make general laws which will contain general principles which are to be applied in every single case, but there might be specific situations where the general principles, if applied, might lead to certain unjust outcomes. So in such case, you do complete justice by applying equity. So that's the definition of equity we come to if we apply Aristotelian definition of equity. So I will repeat this again. Equity does not go against the law. It merely does complete justice. Okay, equity judges do not replace the lawmaker. Okay, so they put their fit into the shoes of the lawmaker and decide the matter by asking, what would the lawmaker do? Would the lawmaker come to such unjust outcome? So the judge will come to the conclusion that no, lawmaker cannot come to such unjust outcome. So to bring about just outcome, they apply equity. So that's essentially the idea of equity. Okay, but as of now, law of equity has also become a body of positive legal doctrines. Okay, they also have become positive legal doctrine. As I told you guys in the last class that earlier common law was basically precedential in nature. Initially, equity was basically application of Lord Chancellors, who also had ecclesiastical jurisdiction. Okay, so he would basically use his own idea of conscience in specific case, though there was no precedent when it came to equity initially in the 13th, 14th century. But later on, there emerged a body of positive legal doctrine, okay, which took the shape of precedents, and equity eventually became positive law. Okay, so that's what equity is all about. Okay, so what is equity as of now? If you ask me that question, okay, sir, you have told us about what equity is all about, substantially, but where do we find equity now? So equity as of now is nothing but body of doctrines and remedies that developed from equity jurisdiction of the Court of Chancery, okay, until its abolition in the year of 1873 and 1875. So basically in those 2 years, equity jurisdiction of the Court of Chancery was merged with that of other common law courts in England. Okay, so until then, okay, all the doctrines and remedies, principles which were developed, as they exist today in their modified forms, because they did not stop developing after that. So they evolved even after that. So as they exist today, okay, which has historically been within the purview of Court of Chancery, is what we today know as the law of equity. Okay, so that's what equity is all about. So I hope you guys understood what equity is. So now I'll proceed to historical origin of equity. Okay, So here's one more thing though. Okay, there are many other definitions of equity given by certain other thinkers. Okay, so what I will do is that instead of reading them out here, because I have already given you guys the essence of what equity is all about, there are certain other definitions that I will share with you. So kindly go through them later on. For now, I will stick to history of equity in England. And this is a topic that you will not find very difficult because you had already studied this earlier in CLS. Okay, so you know that initially, okay, there was no equity. Okay, law of equity. Law of equity emerged only later. Okay, in the 13th century, it had like first emerged. Okay, so with the Norman conquest of England, okay, in 1066, a new kind of law had emerged in England. Okay, and what was that? That was common law, if you remember. Okay, so initially, they interfered only with the taxation matters. Okay, there was a first code that had emerged, if you remember, Scaccarium Regis. Okay, which is like an exchequer. Okay, and subsequently, three more courts had emerged out of them. Okay, and those three courts essentially did what created what we today know as common law. Now, equity did not emerge out of all these three courts that I have just mentioned. All these three common law courts that I have just mentioned. Equity emerged somewhere else, if you remember. Okay, so the origin of equity is to be found in the court of chancery as it exists today. But back then, it was not court of chancery. You would appeal to the Lord Chancellor, who would do king's justice. Okay, who would uphold king's conscience. Okay, so its origin essentially lies in this institution of Lord Chancellor. Okay, later on that became the Court of Chancery. Okay, so its origin essentially is in the, if you just generalize, you can say that it originated in the Court of Chancery. So what is equity? What had been historically done by the Court of Chancery. Okay, so another important thing is that that equity. Okay, here's a distinction that you need to make. Okay, if you remember, I go back to CLS again and again. If you remember, your common law had been very procedural in nature. Okay, because if you remember, there were certain forms of actions, okay, which were to be issued by the Lord Chancellor himself. Okay, he also issued these forms of actions. Okay, now you have to strictly adhere to the form of action. Your specific case has to fit into the requirement of forms of action. And if it doesn't, okay, if you fail in terms of procedural requirements, that then you do not get the justice. Okay, so common law has been very procedural. Okay, but equity on the other hand had been substantive, because it did it basically meant upholding king's conscience. Okay, so it involved many substantive religious principles, because Lord Chancellor also had ecclesiastical powers. So quite often his decision of a particular case would also involve certain higher religious principles. Okay, so it's through that power which was exercised by this Lord Chancellor that certain substantive principles had emerged. Okay, and those substantive principles are basically what we know today as equity. So so equity, when did it for the first time emerge? Okay, so as I just told you, it wasn't there initially. Okay, after Norman conquest until Henry III's rule in the 13th century. During this period of time, you only had common law. Common law. Okay, and how did it emerge? As I just told you, there were three different courts that emerged out of Scaccarium Regis, and what were those? The Court of Exchequer, the King's Bench, and the Court of Common Pleas. Okay, and along with that, you had justiciaries itinerantes. So those were basically the traveling judges who travel around and dispense king's justice. Okay, so those were the courts and those were the justices. Okay, and how they decide the matter, those became the rule of law, and eventually those were followed in subsequent cases, and this is how this common law, entire common law had emerged. Okay, but the problem with these laws, as I just told you, is that these were not substantive laws. They were merely procedural in nature. Okay, and those procedural laws will determine the outcome. Okay, so in the absence of substantive law, what did they have? Okay, they had those crazy rules, if you remember. Okay, law of ordeal. Okay, waiver of the law of ordeal. So basically, to give you an example, to remind you of what we had already discussed, was that whether you have committed theft or not, so maybe you will be tied to a rock and then you will be thrown into the water. If you float back, then you haven't stolen, stolen anything, you haven't committed theft. And if you sink, then of course the justice is done. So that sort of crazy procedural laws were there. Okay, so common law made improvements over that. Okay, so what kind of improvements were made by the common law? So basically they came up with these forms of actions that I just described to you. Okay, so you have to fit into the requirements of specific forms of action, and then based on those forms of actions, the Lord Chancellor will issue writs. Okay, Lord Chancellor will issue writs, but quite often what happens is that the forms of actions are limited. Okay, forms of actions are limited, hence you are denied certain kind of justice because your matter doesn't fit into those forms of actions. Okay, so because of these limitations, as I have just discussed, equity had emerged. Okay, so when did equity emerge? So equity emerged in the year 1285. Okay, basically after 1285. Okay, so what had happened was that Lord Chancellor would try to uphold King's conscience, but he was limited by the common law. Okay, so what he used to do quite often is that because there were only limited number of writs available, in consimili casu, if you remember, this is also something that we had discussed. Okay, in consimili casu, he was allowed to issue writs. Okay, so in between, what had happened was that so the Lord Chancellor started issuing newer and newer, writs. Okay, in newer and newer cases, which was not acceptable. So the power of the Chancellor to issue new writs was restricted to consimili casu by virtue of Statute of Westminster II in the year 1285. Okay, and it is only after that equity had emerged as a separate branch of law. Okay, so what would happen is that when procedures, when this procedural law of common laws would fail, okay, then equity would step in. Okay, so certain examples are there. Okay, why would there be necessity of Chancellor to step in the name of equity? So I will give you one example. So for example, one formal requirement of a valid transaction would be presence of a seal. Okay. So for example, I borrowed certain money from you, and I promise by virtue of a written note with a seal that I will repay the money back to you on certain days. Okay. So I have made the necessary payments. Okay. I have fulfilled all the considerations, but the seal is still there. Okay. So what happens is that the person to whom the money is owed to, okay, despite the fact that the money has been paid, nonetheless goes to the court and then says that, okay, I still have this and I have not been paid, because that person has that particular piece of documentary proof. Okay, in the common law, the judges might have the appearance that the said person is still owed money too, but in reality the money has been already paid. Okay, now if you as a judge were only to look at that documentary proof, okay, then you will come to an unjust conclusion that the money is still owed to, despite the fact that the money has been paid. Okay, there might be certain other cases. So for example, where something has been done through fraud or intimidation. Okay, but there is nothing to prove that except through the knowledge of the specific parties who know about the fact of intimidation or fraud. Okay, in such case, the ordinary procedures which are there available in the court of common law, okay, would not lead to doing justice here, because all these factual matters are out of the purview of the powers of the common law court. So in such case, injustice happens. So for example, in the case of trust, okay, in the case of trust, what happens is that there is an appearance of complete transfer of property. Now, complete transfer of property is recognized by the common law court, but in trust, you know that even when there is a complete transfer of property, it is subject to certain conditions, that certain things be done or the property be transferred to someone else on happening or not happening of certain incidences. Now those other factual facts are not within the purview, within the knowledge of the common law court. So these extraneous facts are definitely taken into consideration by the chancellor. So in such situation where adherence to the common law might lead to doing injustice, the chancellor steps in to do complete justice, and that's how this particular law of equity had emerged. Okay, now this particular jurisdiction of the Lord Chancellor was confirmed by Edward III in 1349. Okay, and after the confirmation, a separate court had emerged. Okay, and that court we know today as the Court of Chancery. Before this, the chancellor would do justice in the name of king. Okay, from the king in council. But after this confirmation by Edward III in 1349, the separate Court of Chancery emerged. Okay, so now the court started functioning independently. So yes, this is how Court of Chancery emerged. Okay, now in such cases, as I have just mentioned to you, the chancellor would intervene to protect the conscience of the king. So even though it is a separate court, it still protects the conscience of the king. Okay, now you will ask me, sir, what is the meaning of conscience? Okay, is the conscience, this idea of conscience that you are referring to, it's personal idea of values, virtues, or justice of the chancellor, Lord Chancellor, or is it something more than that? So what would be the answer to that question? Well, here's the answer. Okay, you might allege what what you just did, as I explained, try to explain. That might be the allegation, justifiable allegation initially as to what the chancellor was doing initially, but not later. Okay, so you will come across two different kinds of meanings of conscience as it historically emerged. Okay, so earlier in the initial times, okay, when the Lord Chancellor started exercising this particular jurisdiction, conscience meant knowledge of facts, okay, that a judge should ideally refer to, okay, in determining a case. Okay, certain facts, okay, that the judge should rely on, okay, to determine a case. But in the common law court, the judge will not have knowledge of all those other facts, okay, in determining the case. So what would it essentially mean in this particular case is that the chancellor will decide a particular case in the light of complete facts, okay, all the facts which a common law judge will not have knowledge of. So that's essentially the distinction. I hope you understood. A common law judge following the common law procedure will have knowledge of limited facts, okay, but a chancellor will have a wider range of facts known to him. So he will do justice in the light of those wider range of facts. Okay, so full range of evidence. Okay, so the chancellor will have more evidence, okay, which a common law judge will not have. Okay, the chancellor will use his own unique judicial process. He will not be restricted by the judicial process, okay, the procedural requirements which are applicable to the common law judge. Okay, so for example, he can compel someone to produce a document, okay, something that the common law judge will not be able to do. Okay, so why is that the case? Because in the common law, there was a protection which was provided to a particular party, a witness, basically a party, okay, who will not be compelled to, who will not be sorry, any confusion? Okay. So, so essentially what the idea is that, so for example, in common law, there was a rule that, okay, a party will not be compelled to be a witness against himself. So what that would mean, back in those times, that, now that is not the case. Okay, back in those times was that, so for example, a particular person, the defendant here, okay, in the court of equity, has recourse to certain documents, but because of this common law rule that I just tried to explain to you, the common law court will not have recourse to that particular document. But if that document was only in the hands, in the knowledge of the common law court, the outcome of the decision would be different. But the common law court is restricted by this common law rule that exists, that no one shall be compelled to be witness against himself. So court of equity, as I was just telling you, okay, it has recourse to more facts, wider range of evidence. So what it could do is, it would personally, so it's kind of in personam jurisdiction that the court of equity has. It can compel one person to produce certain document. So that is the doctrine of discovery of documents. Okay, it's an order leading to discovery of documents. Now see, this is an equitable principle you can also find in CPC if you have studied. Okay, in CPC there is something called discovery of documents under order 11, rule 12. Okay. So this is something that had emerged in the court of equity. So a party can be compelled to produce a document. When the document is produced, there is fuller range of evidence, fuller range of facts, which is within the knowledge of the chancellor. And the chancellor is able to decide the matter in the light of more facts, okay? More facts, apart from the document which, chancellor can compel to be produced. He can also compel someone to say something on oath, okay? So for example, something that cannot be done by the common law court. Or he can also get, okay, the chancellor can also get facts from other people who might be witness to a particular transaction. So all these, newer facts helps the chancellor in arriving at a better, decision. So that was essentially the meaning of conscience, essentially. Okay, so earlier these were quite procedural, as I'm trying to explain to you, but subsequently these became the substantive law of equity. So fraud, as you know, okay, fraud as you know today, okay, accident, okay, or mistake, okay, all trusts, all these were essentially things which were not within the purview of the common law court, but which, by virtue of this wider jurisdiction which was exercised by the Lord Chancellor, became substantive law. Now, for example, I entered into a contract with someone. Now that contract has been entered into and it is written down in a document and there is a seal, but maybe there was an act of fraud from one of the parties, okay? So that was never a defense earlier, okay? But now it has become substantive law because this was created by the Lord Chancellor, and that became the law of equity. So this is the importance of law of equity. So I hope you understood this. So what did it essentially mean? So initially it meant that the chancellor is able to decide a matter in the light of wider set of evidence, wider set of powers that it could exercise to require production of evidence, that it was not restricted to merely finding out documentary evidence, which was the case with common law court. It could also look into surrounding facts. It could compel someone else who's not party to the matter to come before the court and testify. All those wider powers led to the creation of the law of equity. So that was essentially the idea of conscience earlier, that the chancellor is able to exercise his discretion, his judgment in the light of wider set of facts, and that's what conscience essentially meant. Okay. So yes, this is what conscience initially meant. Okay, but later on the idea of conscience changed. Okay, why? Let me tell you why. Okay, So earlier, in arriving at a decision, so quite often, as you know, the Lord Chancellor was not secular earlier. Okay, so back then the Lord Chancellor will decide a particular case in the light of certain religious principles. Okay, so different Lord Chancellors would come; they will come to different conclusions in the light of similar facts. Okay. So that was the problem earlier. But after, they started appointing secular, Lord Chancellor, okay, it took the presidential form, and now they could not any longer come to different conclusion in the light of similar facts. They have to come to similar, conclusions, because they are bound by previous decisions of previous Lord Chancellors, okay. And from that, a different kind of conscience emerged. Okay, now the conscience of the Lord Chancellor is not his personal conscience, but conscience as it evolved historically over a long period of time. So that's the later definition of conscience. Okay, so I hope you understood the meaning of conscience here. Now, let me see how much time I have. Okay, I have some time. So now let's look at something else, okay, that we started with. That yes, we see that Court of Equity, the Court of Chancery, created lot of law of, equity. Court of Common Law obviously created common law. Okay, what if there is conflict between common law and equity? Okay, essentially, the question as it is now would be that what if there is a conflict between equity and common law? Which one would prevail? The simple answer to that, okay, the simple answer to that you should remember is that equity will prevail, okay. But when I say that equity prevails, it doesn't mean again that equity negates common law. But equity is a justice which is done in the light of wider range of facts. So equity leads to complete justice. Hence, equity prevails over the narrow outcome of application of common law. Okay, so what happens if there is a conflict with common law? Then equity prevails. So remember that, okay, if you are asked anywhere. Now, as I just told you that this idea of equitable concept of conscience had changed, okay. Now in recent times, okay, in more recent times, after basically appointment of secular Lord Chancellor, okay, this idea of conscience became certain ethical standards that that a particular defendant will have to adhere to, or the defendant will be weighed in terms of these higher ethical standards, okay. And this will be applied as against the common law. So the defendant will say that, okay, I am trying to enforce my right as it has emerged from the application of common law, but equity will mean that that outcome will now be subject to certain higher ethical standards, okay, certain higher ethical standards. So that's the conflict. Okay, now how are we to interpret this conflict? Some say that, okay, equity clearly goes against the common law. Others would say that no, it is not. Common law comes at an answer in the light of restricted facts, but equity comes to a proper conclusion in the light of wider facts. Hence, there is not really any conflict, but there's merely a complementary justice which is done by equity. Now, this idea of equity prevailing over common law had not been historically without criticisms. Okay, there has been criticisms of this idea of equity quite often coming in conflict with common law. Okay, so it has been said that equity is based on subjective, unprincipled system of discretionary justice of chancellor that undermined common law. So, what is the criticism? First criticism is that equity is subjective. Okay, why is it subjective? Because if you remember earlier, it was about subjective conscience or subjective value understanding of the Lord Chancellor. So that's why that criticism, that it is subjective. It has been called as unprincipled. Why? Because there is no consistency. Okay, there will be different Lord Chancellors and there will be different outcomes. So it was considered as inconsistent and hence unprincipled. System of discretionary justice, because the chancellor gets to exercise his discretion. But then, as you know, later on the things changed, because later on, after the appointment of secular Lord Chancellors, the Lord Chancellors in their subsequent cases were bound by the previous decisions. So all these criticisms eventually vanished. Okay. So the criticism was that subjective, unprincipled system of discretionary justice of chancellor that undermined the common law. Okay. Common law institutions and procedures. Okay. Now this entire criticism had peaked. Okay. Had led to like a very well-known jurisdictional dispute between a very famous justice of the King's Bench. Okay. Lord Coke, you might have heard, okay, Lord Coke, okay, who was the Chief Justice of the King's Bench, okay, Court of King's Bench, and versus Lord Ellesmere, okay, who was the Lord Chancellor, okay, who was the Lord Chancellor from the Court of Chancery, okay. Now, I'm not going into the facts of the case. Facts of the case could be discussed later on. So essentially what happened was that in this particular case, the case is also known by the name Earl of Oxford's case, okay? Earl of Oxford's case, okay? In this particular case, the Court of Common Law had come to a particular, conclusion. So it had decided on matter of right, okay? And it had come to a particular conclusion, okay? So that was the outcome of the Common Law Court, that is King's Bench here, okay? Now what had happened was that subsequently, Lord Ellesmere, who was from the Court of Chancery, okay, he issued common law injunction, okay, restraining the party in whose favor the matter was decided from enforcing his common law right, okay. So this injunction was basically issued to restrain the party who had a right under the common law action, okay, from enforcing his right, okay. Now that led to the clash between Lord Coke CJ and Lord Ellesmere. And this was ultimately decided by James I, okay, in the famous case that I just named, that is Earl of Oxford case in the year 1650. So James I, okay, had decided in favor of the Lord Chancellor's power to issue injunction, okay. So that from that only we came to the conclusion that if there is a conflict between equity and common law, which one would prevail? So that's basically the outcome of this particular case, in which James I had come to the conclusion that Lord Chancellor's power would prevail over that of the common law courts. Okay, so what is the essential outcome that in this particular case that we need to look into? It is that equity will prevail over common law. Okay, if there is conflict between equity and common law, then equity will prevail. Now, this is just a general principle I'm telling you. Okay, so when we look at specific equitable maxims, you will see there are like variations in this. But generally, equity, because it's based on higher principles of justice, it prevails over that of common law. Okay, and there is a principal rationale for equitable intervention, that this equitable intervention doesn't just happen arbitrarily. There is a principal justification for the intervention. Okay. Now this has become all the more prominent now, because equity has also taken the form of common law, in the sense that there are precedents even in law of equity. So that earlier criticism of it being subjective, unprincipled discretion exercised by the chancellor no longer apply, because the conscience of equity as of now is as much principled as the common law is. Okay, so that's essentially what the law of equity is as of now. Okay, and this is the relation between equity and common law as it exists today. So with that, I would like to end my discussion for now. So I'll be sharing this. I hope it's being recorded. And if you have many of you have joined, 19 of you. Thanks for being there. Anyway, but there are many others who are not there. Okay, so if you find anything difficult here, I'll also be sending the readings, okay, that I have been referring to from Snell's book. Okay, I'll be sending that as well. If you have any difficulties in understanding that, kindly feel free to drop your queries here in this particular group, okay, in this Google Classroom group. And for those who are here, go through it once again, go through the readings that I will be uploading. And there are many other readings available online. So go through them. If you have any confusion that you see, you need clarifications for, feel free to write to me. And I will respond accordingly. Thank you for being there, and I'll be sharing this.
Sir, everybody is being curious about the attendance for this class. That how will you mark attendance for this class?
Don't worry, I understand, because the mistake is on our part. So I'll be generous, and everyone will get attendance. Don't worry.
Okay, sir. Thank you, sir.
Ask everyone to go through these lectures and these readings that I'm sending. Okay. Otherwise, it's and next week I hope that there will be certain changes for this class. Okay. So don't worry about the attendance, because I'm taking this recorded lecture without informing you guys. So today I'll be generous. Everyone will get attendance. But in the next class, hopefully this thing will be fixed, and then everyone has to be present. Okay. Thank you then.
Thank you, sir.
Okay.
Thank you, sir.
Mm-hmm.